Hello, folks. It's Alex Woods with the weekly Legal Surgery radio show on YouTube and Zoom. So greetings to all you litigants in person who have taken the brave challenge to navigate the county court or the high court civil system on yourself with support, with the wingman service that we offer. I should probably just first say that do remember that advice, doing a 1 hour legal surgery is general advice, and you invariably will need tailored advice to your own particular case. You probably think that's a bit of a sales plug for lawyers. You are probably quite suspicious of lawyers. They must be one of the very few professions that get paid the same amount whether you lose your case or you win your case. So perhaps the suspicion is well grounded. But by the same token, while the criticisms might be leveled at the legal profession in that respect, we have a problem with a bunch of clients who seem to think that, a lawyer doesn't need to charge for his words, his advice. You never go to a doctor and expect not to have to pay for an assessment. And it's exactly the same thing with lawyers. And it really is a case of penny wise, pound foolish, because if you just do take general advice, a lawyer just simply can't properly advise you. Every case is unique. And actually the legal system and the procedural rules are very flexible to suit the particular peculiarities of your individual case. But hopefully, that being said, with that caveat, and we actually do pump out a lot of free, spend a lot of work on giving people free legal advice and free videos. And we've produced a book, so just put in a plug there, Flying Solo, available on Lulu, the full book, single parts available on Amazon. But that being said, hopefully this legal surgery will give you kind of just to clear the mist a little bit and help you to go in the right direction and answer some simple, basic, general questions. So without further ado, I'm just going to check in with my excellent marketing and radio producer, Kinga, to make sure that there aren't any particular administrative matters that it would be good to attend to. Kinga, have you got anything that you think I should deal with at this stage? Well, I think the lovable Kinga has vanished. Perhaps she can hear me. I'm just going to just check in. A caveat. Yeah, I think I have done the caveat. She says, I think I have just done that. Anything else? I hope over time to have people actually be able to join on Zoom, perhaps a certain limited number of people. Perhaps I'll work out a system where if you kind of properly prep me up in advance, email me, then I can invite you to join as a person, and then we can have people in the room as well as the queries and the questions on YouTube itself. So I have a lot of questions to deal with, it seems. Look, some of these questions really do deserve a legal surgery. We're doing a lot of legal surgeries. If you don't get satisfaction today or on another occasion, just avail yourself of our legal surgery service. We do try and just do a flat rate, 150 quid, speak to a solicitor. And the good thing about those legal surgeries, we think that they work quite well because we can screen share on Skype, we can upload documents, we can actually read, because lawyers are skilled at reading documents very quickly during that call. They really pack a punch, those 1 hour legal surgeries. They're really good value for money because we can make that advice a lot more, not hugely more, obviously, but a lot depending upon the size of documentation. But we can make that, good value for money, basically. Legal surgeries, 150 a pop. Email info@redwoodlegal.co.uk. let me take a look at the questions. Going right to the top here. So, can you see me okay? Right. So, forgive my wonky glasses. I managed to step on the other day. I haven't got them replaced yet. Right. Troy asks, what areas of law do you talk about? We specialise in civil litigation. Okay. I first started in civil litigation, having been a criminal litigator 10, 15 years ago now, because, well, for various reasons. But I think this is a good question, really. I think that there's a big difference between lawyers who are non-contentious, who do your conveyancing and draft your wills, and those who litigate. It's just a completely different mindset. A litigator is a fighter, is a street fighter often. And that just a whole, as you can imagine, there's a whole different mindset to drafting documents, drafting wills, and taking care of that side of the thing. So we don't do any non-contentious work. We work with a sister company that does non-contentious work if that is needed. In the area of civil litigation, we particularly specialize in contested wills and in cohabitation property disputes. But we actually have a family specialist in the firm. Daria has done a lot of family work at her old firm. But we don't specialize on that. We can do a bit on the side for valued clients, because civil litigation is quite different from family. And actually, for example, divorces are quite different from where you're not married. There's a whole different law. It's civil litigation. It goes through a whole different court system. There's family courts with family judges and civil courts with civil judges. So we don't go into the family court realm very often. I mean, sometimes it comes up, with a child, an unmarried couple who got a kid, but on the whole, our focus is on civil litigation. But I mean, that being said, we do a lot of general litigation. We've had a lot of building disputes recently, both actually for claimants, defendants, builders, people who've had their kitchens extension mucked up. We also do, my background is financial mis-selling litigation, suing banks. And we also have a lot of experience of no-win, no-fee work and contingency agreements. I think that a lot of lawyers out there don't give the full service. If you're a, samurai lawyer and you're going into battle, you need all the weapons in your toolkit that you can, you don't just need a sword, you need a bow and arrow. And I feel that a lot of lawyers are very scared of no-win, no-fee because you don't get paid for a long time, and the lawyer has to put his mouth where his money is, or his money where his mouth is, because he becomes a partner with you, because he only gets paid if you win. So it's a particularly unique type of retainer, but it's important to be able to offer no-win, no-fee retainers, because certain cases they're perfect, other cases they're not appropriate. So this is this is to wrap up this question. This is why it's important to find a proper, true litigator who can offer you the full range of services and can do contingency agreements as well, like it's famous in the States. They do a lot of contingency deals in the States. So I've got Mia here. Good afternoon, Mia. Unless you tell me in this thread that there's confidential information in your question, I'm going to talk about your particular matter, okay, and hope that your opponent is not listening in too. Just a caveat there. So she was taken to court in 2008 by a car finance company, asked for a payment holiday, so on and so forth. The company took the car and they sold it on auction for a pittance, and they took her to court. Oh, cool, blimey. They're pretty kind of, what's the word, can be pretty aggressive when you get down to the small print, these types of agreements. Entered into a payment agreement, yes. Quite a long thread here, Mia. You know what, Mia? That's just such an extensive comment. I do invite you to email into info@redwoodlegal.co.uk I'm sorry to say it's just because of pressure of time. If I've got time at the end of the hour and I haven't answered everybody else, I'll come back to your question. It's just there's about 10 paragraph blocks here, so I'm afraid I'm going to move on. KBPALS, Patient Advisory Liaison Service. Officers have always had their doors permanently closed to people, pretty non-existent post-pandemic. What's your question here, I think, is my question in response to your statement. Have you got a particular case? Is there a dispute here? I would need some more details from you. Connie, obtained judgment against a fraudster who owes £6,250. However, the High Court enforcement officers are not able to visit homes because of COVID-19. When will they be able to mobilise? Yeah, I mean, it's difficult chasing down defendants, court judgments at the best of times, let alone with the COVID-19 complication. I don't know, without doing legal research and not knowing. It's not like we're enforcing cases every day. I mean, we just every few months we might have an enforcement issue come up in this firm. So I don't know what the current state of play is and when High Court enforcement officers will be able to mobilise. I guess you've kind of contacted them or been on websites and just tried to get some sort of. Surely the High Court enforcement officers will have made some announcement on a website somewhere as to the current situation and when they'll be able to go back to work. Right. KB, are our courts geared up for recognising that even patients with breathing difficulties need protection? That's a curious collection of interesting and curious collection of questions here. I think it feels like you're all plants who've been designed to give me tricky ones today. Are our courts geared up for recognising that even patients with breathing difficulties need protection? You're talking about, obviously, I imagine you're talking about what arrangements courts make to deal with people who are in, who have disabilities, basically. I mean, I think my first thought is that surely where online, the world is online, and so much of the court world is now going online, and in fact the courts are setting up an online court system which is going to be free of a lot of the complicated civil procedure rules that litigants in person have to deal with. The courts have finally acknowledged that's a problem. Anyway, generally, and I'll try and remember to, but please do ask me, keep you updated with that online court. It's not going to come in next month, but it's in the pipeline. But yeah, I don't know when we last had a physical hearing. Most courts are online at the moment. I can't answer off the top of my head what the specific arrangements courts make in relation to actual appearances at court, hearings at court, in respect to people with breathing difficulties. So I'm going to move on. Shazali, good morning. I have a cafe and I would like to make a business interruption claim against my broker. Is it possible if I can get help with a letter of action? Well, absolutely. As you will see from the courtwingman.com site and from our videos, we, as well as doing, normal litigation, traditional litigation, we are building this standalone business where we offer you really three basic things: 1 hour legal surgeries, a proper review of your case, the merits, the amount that you're likely to win, if you're a claimant, and tactical issues and any legal research and procedural steps that you need to follow. That's a sort of second service. That's sort of 3 hours on average at £150 an hour. And then we also do drafting work. So if you want a particulars of claim drafted or a letter of action drafted, obviously a letter of action is very important because you then adapt that into your particulars of claim. It becomes a template almost. Then again, it could be anywhere from 2 to 3 up to 5 hours in most claims, not obviously high value and complex claims. So that's a service that we can offer, and I think we're probably as competitive as anybody. I would like to tease out more from your question, business interruption claim against your broker. I don't quite know what the detailed circumstances are. Feel free to post more below or email us separately. I notice you've purchased our book and you've received it today, so maybe there's the answer. Read the book, and if you're not satisfied or skim read the book, then come back to us at a later legal surgery or for that advice that I'm recommending, rather that drafting work that I'm recommending, and just email us at info@redwoodlegal.co.uk or hello@courtwingman.com, hello@courtwingman.com. Mia, excellent. You purchased my book. Anybody who purchases the book and they like it enough that they post a review gets 5 gold stars and will make me very emotionally favorable towards queries on this live chat, simply because reviews are the currency on Amazon in terms of getting your book up the rankings and reaching a wider readership. Julie, thank you very much. Great idea. Is that a great idea to purchase the book or the great idea to do these legal surgeries? I'm sure you mean both. Thanks. Redwood Legal, I think King has stepped in. There's a link to the book on this live chat. Mia, I really do. I will, as I say, I will come back to you. She's posting like a merry trooper. In fact, I think she's by far the majority contributor to this live chat. So perhaps we will come back to you towards the end of this hour. Connie, is it still worth making small claims if the enforcement process is hindered by COVID? Well, look, yes. I mean, enforcement is a problem in any event outside of COVID. When it occasionally comes up, and it comes up, I reckon, in about 1 in 10 or perhaps even 1 in 50 cases, doesn't come up very often, then you have got a little bit of annoying battle. Forms can be complicated. You've got to make decisions which a court to go with, because there are 2 different types of enforcement courts or procedures, which is a headache. And then, of course, you've got to start seizing property and sending in bailiffs if necessary. And it is it can be a right royal headache. Now, you've already got enforcement proceedings underway, it seems. But to answer the general point, I wouldn't be worried about the enforcement being hindered at the moment from making a claim. Quite frankly, the vast majority of people, defendants, let's say, are going to take legal proceedings seriously, and probably not if you don't issue a claim. The favorite tactic of all defendants is to stick your head in the sand. They're ostriches, most defendants, where you've got genuine merit. And as much as, the civil justice reforms and Lord Wolfe talked about how important it is to try and settle your dispute without recourse to legal proceedings, the simple fact is, it's just a fact of life, isn't it? People, people use mediation sometimes to avoid and evade and just string things out. We just in the last 6 months, we've had a lot of cases where our clients have been with other law firms. These are quite big, some serious contested will and property cases, and they've already spent about £15,000 on solicitors going around in a big circle, talking about mediation, sending letters backwards and forwards, not really going anywhere, not getting any real traction in their case. And those solicitors just aren't issuing proactively and promptly enough. And, you know, really sometimes you just have to bite the bullet, because if you're a defendant, you know that the claimant, the biggest card you've got to play is the defendant's fear of issuing proceedings and the big bugbear of legal costs dwarfing any eventual payout. And they're relying on your fear. So the answer to this is to get properly prepped up, to really understand how strong your case is, what value your case is, be making a commercial decision, not an emotional decision about whether or not the rewards are likely to justify the investment in litigation. And once you are properly prepared for battle, then you press the button, and you have to go for it. So that's rather, to come back to this, enforcement process. It's really, I would say, for most people, the least of one's worries. Bigger worry actually is suing a defendant, such as a builder who has a limited company, is a bit of a cowboy and keeps dissolving his companies and creating new ones. That is an issue, because then you spend all the money on bringing a claim against the defendant, who's a limited company, limited liability, and you can't go behind the company very easily and enforce the judgment against them. So, yeah, that's, I think, what I have to say on that. But Connie, by the time the COVID clouds lift in the spring or summer, anybody who's bringing a claim now is not going to end up in enforcement for 6 months or a year. So hopefully things will have returned to something resembling normality by that point. Oh, Judy, thank you very much. Loving a Lawyer Investigates. Yes, I have become a bit of a renegade. I went on a trip to Sweden in the spring of last year. I thought this coronavirus might be really serious, and I'm afraid I made a long documentary series about it by interviewing people, some professionals and regular folk in Poland, in Sweden, and in the UK. And I don't like going against the general grain and the narrative. I've always been a bit of an establishment lawyer character, white, middle class, public school educated, all the rest of it. But I just feel there's something wrong. There's something fishy about what's going on with the coronavirus, because the measures seem way out of proportion to the actual threat. And I wish they'd taken proper steps at the very beginning to actually help those who were most in need, the vulnerable and the elderly. But it seems as if all the healthy people, particularly the children, are being asked to pay for the price of, it's a bit like using a blunderbuss in a kitchen to kill a nasty hornet. You might kill the hornet, but you're probably going to do a lot of collateral damage. That's my soapbox on Corona. Mia, yeah, I'll come back to you, Matt. I promise, I'll try. Do email me if I don't, and we'll try and do it offline. Connie asks, a neighbour is dispensing water onto our development site. My solicitor sent a letter to desist, but they have not removed their felt roof off the dividing wall. What more can I do that is not costly? I think a question that immediately arises here is, what is the damage that's being caused to you? And have you sat down and calculated the costs, both short-term and potential long-term costs? You suggest that maybe they have taken steps in response to your solicitor's cease and desist letter, but not sufficient steps because they've not removed their felt roof off the dividing wall. I think, I mean, don't you need a follow-up letter specifically identifying the problem of the felt roof, and with, breaking down, perhaps in a little table, but quite in a quite mathematical and analytical and surgical way, the damage that's causing and the likely damage it might cause. There's nothing like a figure, 13,000 or 38,000 pounds is the likely damage, and this damage is ongoing and likely to increase over time, to concentrate a potential defendant's minds on the issue. If that second follow-up letter fails, then you're looking at you're looking at legal proceedings. Really, I don't know what much more you can do that is not costly, other than, as I say, buy my book and perhaps have a legal surgery, actually, because this might be an area which would be helpful, because the solicitor can look at your letter and look at the history of what you've done to date, and probably advise you on what you could do that is not costly going forward. I think at the moment that's the best sort of general advice that I can offer on that issue. And the other thing is, having sent the letter, people are often afraid of picking up the phone and finding the person who can the decision maker and having a conversation. Lawyers are afraid of that too. Sometimes I find a phone call, particularly if it follows a nicely polite but firm and robust letter, can unlock something, because often there's kind of some emotional side to these disputes, and you almost need to dissolve emotions before you can reach some sort of accommodation, some sort of agreement. Because solution to this problem of the felt roof, So, Steve, hi Alex, what percentage of defendants would you say decide to pay up once they receive a summons? All right, so summons is perhaps an old-fashioned word. A claim is what you're asking. A claim form lands on the doormat. What percentage decide to pay up once they receive a claim form? I can answer in two ways. Firstly, what our experience is, but that's not going to be the full experience, is it? Because a lot of people never come to us because the person pays up, and therefore they don't need lawyers. So you've got to bear that in mind, that the figures I would give you are likely to be skewed. I know that the court does produce statistics on, claims issued, claims settled, claims that reach trial. And that data is available somewhere. Try Googling Her Majesty's Courts and Tribunal Service data on, claims issued in England and Wales or something. You might find, you might well find some statistics there generally in terms of the percentage of claims that are issued and contested. I think you probably would, actually, because I think the court would have records of those claim forms where a defendant had ticked the box, I accept liability, I do not intend to defend this claim. In terms of us, I think basically very rarely do defendants just flop over after a claim, but what it does is it unlocks things and leads to things like mediation, negotiation, a stay for mediation, and basically you get them to sit up and take matters seriously, and so there's not a big opportunity there for resolving the dispute. In terms of the percentage, I wouldn't say it's more than 50%. Most defendants, if they respond with a defence, yeah, then they're likely to battle on a bit. But very, very rarely do cases go all the way to trial. You'd be surprised how low the percentage is. I think it's like, 2 or 1% of issued claims. It's very low. I tend to find that defendants only settle, or claimants, if you're a defendant, when you get in front of a judge. I remember famously one of our cases settling only when both parties were in the room, in court with the lawyers. The court hearing was only half an hour, but we then had 2 hours of negotiations because everybody was in the court building and minds were focused. And each party suddenly got a realistic view of what they were likely to win. I never like, as a claimant, to agree to vacate court hearing, because I think bringing an opponent into court in front of a judge just exercises people's minds and makes them wake up. Shazali, okay. This is the question that was asked earlier about drafting a letter of claim for business interruption due to COVID-19 and the recent Supreme Court judgment. I'm afraid you'll have to remind me of which Supreme Court judgment you're referring to. We've had some COVID type business, but not much. We haven't had any clients. Well, actually, it's a shame. Daria is on holiday today. We did have a claim last year with a business that had to close and had an overall landlord. I think, if I recall, it was a shop within a complex, and they wanted to keep running, and the overall landlord let them run for a bit, but then closed them down. I would have to speak to Daria about what is quite a specific query, Shazali, but we have had a case like that. Feel free to email in or wait for a later legal surgery when Daria is in the room. Can a company reasonably expect you to keep up standing order payments if they failed to provide you with a standing order mandate quoting their new bank account? Well, if you've been paying into an old bank account off of the original standing order, and they haven't notified you that the bank details have changed, it's their problem, isn't it? But what can often happen with these types of things is, particularly in this day and age where you can communicate in a zillion different ways, is you discover this big company thinks that they have provided you with the details of the new bank account and you've ignored them or something. And so that triggers a system, a bureaucratic corporate system, where you then get bumped into a debt collection department. And as often as not, it may be a case of you being quite clear with them that you've not received new bank details. I mean, that seems to me sort of quite just self-evident and good common sense. But it may be that there's confusion on both sides as to whether or not those bank details have actually been provided. Connie says, let's just have a look at what Connie's earlier question. I'm coming back to the neighbourly dispute in which Connie's solicitor sent a letter to desist, but they hadn't removed the felt roof off a dividing wall. You are right. I sent a follow-up letter that was robust, setting out the damage and possible loss when the unit is developed. No response. I don't want this to hinder our sale later on. Have they got all the proper planning permission? it seems to me as if perhaps you could endure the works and the temporary nuisance, particular specific head of law, of the water, but coming onto your property, but that you're more concerned about the long-term impact on property values. And I guess that I would imagine that when they were granted planning permission, and goodness, I am just giving very general advice here because I don't know the facts of this case, there would have been certain conditions imposed upon the developer. And you might want to get hold of that planning permission and just check that they are undertaking the works in compliance with the terms, as laid out in the planning consent. Because if they're not, that's something you could raise with them. And I doubt they'd like that very much. Maybe these are the sorts of creative ways that you could get them to sit up and take attention. Very good. Yeah, Steve, I would research that. There are statistics. There are statistics on what percentage of claims capitulate, fold when upon receipt of a claim form. I would think it's probably quite a large percentage. I'd love to know the answer to that question myself. I might try and research it if we have some time. Julie says, defended a claim from a solicitor acting for an electric company. Solicitor now saying will accept 300 instead of 650 to settle. Not sure what to do. Wow, interesting. When you think about it purely tactically, and remember, civil litigation is a dogfight. This electric company does not want to spend more money on its solicitor bringing a claim for a small amount of money. I'm assuming you mean £300 rather than 300,000. They're not going to want to bring, it costs their solicitor £300 to bring to write a letter. So this really, you do need to get this matter settled because you don't want a county court judgment, obviously, and it would be unfortunate for the sake of 300 quid. You got a judgment that affected your credit rating and meant you couldn't borrow in the future and meant you couldn't get a mortgage or whatnot. Hey, so 300 quid looks like a low value. I don't know what your financial circumstances are, but it might be an offer that's worth accepting, unless you really think there's no merit in their claim. But if you think, well, they've probably got a little bit of a case here, I wonder whether or not discretion isn't the better part of valor, and you bite the hand off for 300. General advice, Julie, you'll have to take that and apply it to the individual circumstances of your case. Just to come back to the water egress, the planning, the developer. Well, I'm sorry, Connie. I think I need to know a little more about this case, about the facts. A neighbour is dispensing water onto our development site. Sorry, are you the developer, or are you just, is the neighbour the developer and you're suffering? I'm assuming that your neighbour is developing a site next to your house, your property, and that's causing you a nuisance. She says we have planning permission, started the development here. So it sounds as if you are actually doing the development yourself. I think I'm going to need to know. I think I feel a little bit shooting from the hip here. I would need to know more about the individual's, details of this case. I need to keep this legal surgery general and try and tease out general points. I think I've probably done that here. In relation to the specific queries that you're raising, I think I'd need to have, and when we get approaches from clients, and we'll read something quickly, just obviously just for free to see what work is involved. I find this is quite a good general point when you're approaching lawyers. Keep lawyers happy. And the way you can keep lawyers happy and keep costs down is by telling the story in clear chronological order in one email, like 3 paragraphs, maximum 5, 6, 8 lines a paragraph. If it's a long email, I won't read it. I'll say, oh, this is going to be a lot of work, and I'll quote a price to read it. If I get an email that's really nicely drafted in clear chronological order with dates, and it's quite short, and it attaches like a dozen documents in one single PDF in chronological order. I've made a video on how to organize your paperwork on the YouTube channel and how to approach solicitors as well. So I'm gonna put it in the box here, because if you do that, it's just something about human nature. The lawyer will then be a client who's organized and is going to make my life easy, and they will, probably read it and probably flick through the documents just because you're organized and they can quickly get a sense of the case. So even doing that, Connie, you'll get a response from you'll get a favorable response from the solicitor, and you might find the solicitor actually read it and give you 10 minutes on the phone free. Or I think solicitors should be able to, offer legal surgeries, or you send this email and they say, well, I'll give you some general limited advice on the documents that you provided and the email and the phone call. I will give you some advice, but you need to understand that the advice that I'm giving you is based on what you've given me. So don't later on, when there are more documents come to light, come back to me and say you got the wrong advice. You see, lawyers are quite nervous about giving advice when they don't know all the facts and when they don't know what the opponent is saying. They don't know both sides of the story. But if you prepare a nice email like that with a PDF attached, in chronological order, it's not rocket science, then the lawyer is far more minded to give you more of his time and to quote you kind of a low price and give you some good advice just over a 1 hour phone call. As I say, we do find these legal surgeries are very helpful for clients. So I'm just going to put that link in the box, because I do talk about paperwork. It's just so important. I think I've said somewhere in a video or in my book, I can tell who's going to win and not who's going to win. It's those people who are organized. It's always those people who are organized and are not emotionally caught up in their case. Just, doing a job. They've been ripped off by someone. They've been professional about it, and they've organized their paperwork. And that is as good a litmus test of success as any. I think it's partly because when you do the exercise of properly preparing your case and getting yourself organized, you get a sense of perspective on what you're entitled to, what you really are entitled to. And you kind of have to be honest with yourself about, well, I wasn't perfect, and so you then you're more prepared to be realistic about the quantum, the value of your claim. So I've just put that website address because there's 3 videos on there, which aren't too long, 7 minutes, 5 minutes each, which may help. Julie says Lowell's Debt Company, or is it Lovell's? But that name rings a bell. Connie, we are the developer. Follow the advice and email us. And I'm sure we'll be able to help without breaking the bank. Shazali FCA test case 2001 against the insurers in the Supreme Court. Oh, yeah. I did come across that recently because we've got a big housing disrepair case going on with an insurer involved. I think that's just too big a question to handle in this hour, and you're best contacting us independently. Let me just quickly go back up to your early comment. Yeah, I think Shazali, it's one of those cases. I'm afraid I often find myself sounding like a bit of a crack record, but I think you need tailored legal advice on that issue. Right, DNASP, what can you do if you know you have a case against an organization, but they keep withholding information and applying unlawful redactions to stop you investigating and gathering evidence? That sounds like what's been happening in the Scottish Parliament with the salmon issue up there. There's an inquiry by the Scottish Parliament into a potential conspiracy to basically ruin salmon's career. And what's so interesting about that case is that the Crown Office, the Scottish equivalents of the Crown Prosecution Service, are in the cabinet, and they have been redacting critical information and withholding information from the parliamentary inquiry itself. So it happens at all levels. I find this happens with big banks that we're up against, or big corporation or hospital. You say that now, if they're withholding information, you've got two options in terms of proceedings. One is to basically make a pre-action application for disclosure. So now that is like, you haven't issued proceedings. Let's say you're suing a bank and you need your credit agreement and your loan agreement, and they've not supplied it. Perhaps you've tried a subject access request under the Data Protection Act, and that's where you might look at an application for pre-action disclosure, and that's where you really can't get your case off the ground and issued without having those documents. The danger with those applications is the court can say, or your opponent will say, you're just on a fishing expedition. So you have to be able to explain to the court why it is this document is so critical. You don't make it just for general disclosure. If it's for general disclosure, you're best off just issuing proceedings. And then once you've got the leverage of court proceedings and a court timetable and the costs, punishments against parties that don't comply with court orders, that's when you ask that information. And ultimately, you may make a disclosure application during the course of those proceedings if they fail to comply at the disclosure stage. So in terms of redactions themselves, well, yeah, that's, I mean, you could, although I'm a bit rusty on this, you could be asking the court to have a look at the redacted sections and not disclose them to you, and to make a assessment of whether or not that this document should have been redacted. Right, Tony Coe says, you gave me great advice on a previous occasion under your small claims service where I was the claimant. It was a very successful outcome. Thank you. I now have a claim, I think, as defendant. I think you're saying. Well, I'm glad that the advice has been useful. And yeah, good luck if you need some more advice. buy my book or give us a call. Right. Good. Mia says Flying Solo is a treasure, and that's the book. Thank you very much. Please say that on a review, and you will be my friend for life. DNASP, I've tried numerous subject access requests, complaints to the ICO, but they don't enforce anything. Yeah, it's almost as if, the Parliament creates these apparently powerful new Data Protection Act laws, but when you get into the dogfight of proceedings, the problem is with civil proceedings is you got to spend money on enforcing your rights and time. And it can be really annoying. It's often why I try and sometimes encourage people to issue a claim. Because once you've got an issued claim, if you win, you get your costs awarded against your opponent. Whereas if you try all sorts of other avenues other than court proceedings, you usually end up in a situation where your opponent refuses to pay your legal bill, even though you might feel justified. There's an interesting side note on that. And actually, we've got a case that falls into this area at the moment. You can bring costs proceedings. Let's say you've settled a case without issuing proceedings, or settled a matter without issuing proceedings. You can then make a Part 8 application to court for your costs. It's not often done, and it's a little bit trickier than costs being awarded to the winner once you've issued a claim. But it can be done, and particularly where you use Part 36 offers, a special type of offer before issue, and then the other party accepts that offer, but refusing to stump up your legal costs. And don't forget, just because you're not a lawyer, you may have legal costs, and don't forget that litigants in person, in certain circumstances, can claim for their costs, their time. You can go to the cost court to get your costs awarded against your opponent. Now, to come back to this point about subject access requests and complaint to the Information Commissioner, this is the Information Commission is apparently meant to deal with these sorts of complaints. What can I tell you? We live in such a bureaucratic world where everyone sort of pays lip service to data protection, but then in actuality, actually getting the documents that you need is a whole different kettle of fish. If it's a serious and a high value claim, you kind of got to, and if you're dealing with a big company, that they're just going to ignore you, sadly. You could try going to an alternative dispute resolution outfit like the Financial Ombudsman Service, if they've got a regulator, and applying pressure that way and getting them to disclose information. Otherwise, you need to make sure you've got the proper paper trail showing that you have exhausted avenues of pre-issue resolution, and then issue a claim and get the documents off the basis of an issued claim. It'll be much easier. Yeah, we've got a lot of disclosure here. I'm going to round up after Connie's final query. So I've just got 2 or 3 or 4 more. So don't put any queries through yet. Sorry about that. We seem to have something going on in the background here. Let me see if I can get rid of that. I'm without my assistant today, and I'm the only one in the office, actually. So, disclosure and transparency in respect of the NHS and police, who are clearly abusing, hiding information to stop a case against them being built. I think I've kind of already given the answer. You could bring, if you think that the documentation is so important that you just can't effectively plead your claim without it, then you could make an application for, pre-issue disclosure, okay? Specific application. Otherwise, you've kind of got to use the leverage of civil proceedings, the baseball bat of a claim, in order to get them to take matters seriously. Because people only do things when there's an equal amount of pressure applied because they're not doing something than if they are, if you know what I mean. And if they get a letter or a claim, or if they get a solicitor's letter, I mean, this is another thing. If they get a solicitor's letter on letterhead, the NHS or the police, what have they got to do? They've got to go to their own lawyers. They've got to ask their own lawyers to get involved. That's a headache. That's management time. That's money. They might then take your letter seriously, particularly, as I say, if it's on solicitor's letterhead. But otherwise, you've kind of got to find a way to bring proceedings against them. Do you think that cases like, I've got a query here about a case I'm afraid that I don't recognise. It's about the acceptable standard of hospital professionals, and it seems more of a general query on hospital professional policies. I'm afraid, owing to time, I'm going to skip that. Apologies. Here we go. Shazali asks, what is the difference between a Part 36 offer and a Calder Bank offer? Yeah, Calder Bank is the old, traditional way of making an offer. I think originally the idea was that money was paid to court, so that, you'd actually shown that you were serious about an offer that you'd made. It's not an expression that is frankly used any longer. The two offers, just to be more general, help to everybody, there are two sorts of offers that you can make in civil proceedings. And one is just a normal without prejudice offer, and the other one is a Part 36 offer. I do deal with this in videos and in the book. Now, I would not advise anybody who's not legally represented to do a Part 36 offer, because of the technicalities around it. You could slip up and get it wrong, such that it's just simply not effective. Hate saying that, because access to justice for all and all that. Maybe when this online court is introduced that I was speaking about earlier, then they'll make things easier for people. But right now, Part 36 offers are quite complicated. I don't think I've ever been on the end of a Part 36 offer from a litigant in person. Doesn't stop you doing one. I mean, you could draft one, couldn't you, if you think you're a legal student, or think you're pretty good, and send it to a lawyer to check to make sure it's Part 36 compliant. Now, I'm not going to go into what a Part 36 offer is in detail, because, as I say, I've done videos on this and it's in the book. But it is a powerful type of offer, because it has, for example, your opponent will have to pay kind of like an extra amount of costs if they don't, when it comes to trial, win higher than your offer. So it's kind of a mechanism to force both defendants and claimants to make offers that they feel are just horribly low early on, and where there's punishments for the person who has, like, if you're a claimant and you make an offer of 10,000 and you only win 9,990. If you make an offer of 10,000, and you only, let's say, let's say you win a lot more than, or even just a little bit more than you've offered, No, I'm getting a bit mixed up. It's been a long hour. I would prefer that you look at the videos and look at the book and come back to me if you've got specific queries, because this is just going to otherwise turn into a long conversation. The main point is it is a powerful tool, and it punishes an opponent who doesn't make a low, realistic offer early on in proceedings, or even pre-issue. You can make Part 36 offer before you issue proceedings. Okay. The more traditional offer is just simply making a without prejudice offer on the email or the letter, clearly putting without prejudice on it. And what that means is you will get brownie points when it comes to costs with the judge if you've made those offers, because offers are all about, the judge doesn't see offers until he's made a decision on the case, who's the winner and who's the loser. Then he takes out offers, because then he's got to deal with costs, who to award what level of their costs. And if he's got a nice without prejudice offer written by a litigant in person that's like, let's say £7,500 and they've won 10,000, he's like, oh my God, they tried to get rid of this dispute by offering 2,500 less than I've actually awarded at trial. I'm going to award them all their costs. So without prejudice letter is really the best thing for a litigant in person to use. You can also put without prejudice savers to costs. That's a technical point, but it means that although it won't be used in the main proceedings and the judge isn't allowed to look at it during the main proceedings, if you subsequently have a whole other separate set of proceedings on the costs, then it can be disclosed to the judge. So here's going to be the final question of the morning. Does Redwood Legal advise judges on litigants in person? The first judge in the fraudster case told us it was relaxed, then laid into me halfway through I was the claimant. Do we advise judges? No, not specifically, although we're planning to send the book to some judges. I think the question behind this question is whether judges treat litigant in persons differently. And I actually think that most judges do. I think they give them far more rope if they're not legally represented. I really do. They are ultimately constrained, but of course you never hear about the knockabout of the day-to-day cases in court and the way judges are just simply exercising their own discretion. You only hear about Court of Appeal judgments which say that things like, well, litigants in person, because there was a recent judgment on this, have to comply with the same rules of service as a lawyer. They can't be excused of the civil procedure rules. So, but that kind of gives a skewed picture of how judges are likely to moderate themselves when it comes to dealing with litigants in person and giving them more rope. Doesn't, as Connie points out here, doesn't stop a judge laying into a party and a litigant in person in proceedings, because as often as not, the problems with litigants in person is that their cases are in a mess, loads of paperwork. It's not so much about applying the civil procedure rules. They just haven't done things on time. They haven't, or they haven't actually. They've brought an application, but they haven't sent it to their opponent, so their opponent doesn't know how to prepare, and they're out trying to ambush their opponent. And there are all sorts of 1,000,001 reasons, which aren't really about the complying with the civil procedure rules of the letter, but more about, being sensible in the way that are bringing proceedings. That's where judges get annoyed, particularly if you turn up at court trying to ambush your opponent. You're making an application and you haven't given your opponent that application 2 weeks previously so they can put in their response to your application, for example. Okay. Yes, a pre-action disclosure could be brought against the NHS and police. Yeah, as I say, make sure it is essential to the documents essential to your claim and not just general stuff, you could be accused of a fishing expedition. That's often why I, as a solicitor, don't often use them, actually. Okay. Sorry about that, and sorry to Mia, because I've run out of time and haven't been able to answer her query. Feel free, Mia, to put your query into an email to us, and we'll see whether we can give you some kind of general advice. Right, I better wrap up for today. We will. This is just us getting online, getting going, just trying to start these routine legal surgeries. This is only the second one that we've done, and we will. I'm sure we'll get better and more effective with time as time goes on. Perhaps get people to join the meetings on Zoom, have invitees. Perhaps in time have a proper radio show with fellow guest professionals who specialize in certain areas of law. I really should do something about these glasses. Take them off and make it a more regular event, time permitting. I'm trying to restructure the business in such a way that we will have more time for this kind of radio show, legal surgery type approach. So thank you. Excuse me. Thank you for tuning in. Sorry for the slightly short notice. Of this event, we will try and eventually find a regular slot every week or every 2 weeks. So I think that's all for today. And as a final thing, I'll just put a couple of links in the description box below.